My name is Melissa Gragg, and I'm a divorce valuation expert in St. Louis, Missouri. I work with business owners and entrepreneurs in every stage of the divorce process, whether in mediation or litigation. There are so many questions and myths about what happens in a divorce when you own a business. So here are some of the top valuation issues every business owner should know before you file for divorce. So one of the questions people will ask is, should I get a business valuation done before I file for divorce? So most people always want to do kind of pre-divorce planning, or at a minimum know what the business is worth before they even decide whether to get divorced. So typically the business owner will reach out to a valuation expert and say, I want to try to get a valuation number because I'm doing some strategic planning, or I want to know what the business is worth for internal purposes. Typically the owner will not tell this valuation person the whole story, or that they're actually considering getting divorced. This could lead to a serious issue in the future divorce process if you actually get a valuation in writing, as of any type of date or for any purpose. You see, this report and any emails you exchange with this valuation expert could now be discoverable. What that means is that any email or conversation you have with this person could be shared with everyone in the divorce process, even if the valuation took place prior to the divorce. So now this business owner could have done a few things differently. When they had originally got the first valuation, they should have just been clear about the reasons for the valuation and that it was primarily for a potential divorce. And if they worked with an expert who routinely did valuations for divorce, then that expert would have told them that they should not put anything in writing, but that they should have a verbal discussion about the value. This would have also allowed the business owner to use the same valuation expert for the divorce, which means all the work that they put in to try to determine what the value was prior to the divorce could still be useful in determining the value at the date of divorce. One of the things that you have to keep in mind is that when we serve as an expert witness in a litigation, we're not covered by the same privilege as your attorney. So an expert is there to help the judge understand the financial situation of the company and of the couple. I'm there to serve the court, not to be biased towards one side or the other. So when you have a conversation with an expert witness, it is not privileged, which means that the expert can be pulled into court to discuss what you've told them. The expert may also have to produce all the emails that you've sent them. So when you send an email that says, make that business worth nothing and I don't want to give my husband or wife a dime, that usually won't go over very well with the judge when it's produced in court. So a business valuation expert is bound by confidentiality, which means that they won't discuss the nature of your business or your financials with other people outside of the divorce, but it also means that when they are subpoenaed for trial or for even a deposition, the other attorney could ask for all of the emails, all of the interactions, all of the notes, and anything that was developed and provided by that business owner under any context during the valuation engagement. The divorce lawyer could ask for offers to buy your business if you've received any offers, either in writing or in email, and any other valuations that you've had over the past 3 to 5 years. So the attorney could ask for information in the first valuation expert's files, even emails prior to the date that you filed for divorce. So this means you need to work with somebody that knows how to value your business, but also knows how to testify in court. This will allow you to understand the value of your business prior to filing for divorce, but also not to have any documentation of that number or any prior valuations that could be discoverable during your divorce. Basically, this also means you need to be very honest with the valuation expert about the reasons why you want to go through the valuation process, and to work with somebody who understands the nuances of divorce court. So you've decided to get divorced, and in addition to getting all the financial documents together for the valuation or divorce process, you also need to go about running your business. So another question I will get is, how should I run my business if I'm getting a divorce? Do I take on more debt? Can I start a new business venture? I usually tell people that they should continue to run their business in the same manner as they did prior to the divorce, and not to make any decisions that they think will make the value lower or higher, or do things that they think are more advantageous in their divorce litigation. Here's the thing. Most of the time, if you decide to do something different in order to increase debt or reduce your profit, which you think will help you in the long run, it could potentially backfire on you. The historical financials, revenues, expenses, profits, losses, assets, debts, they all tell a valuation expert a story. And most of the time, the valuation expert will be looking at historically what has happened over the past 3 to 5 years, or maybe longer. And this history will tell a story about how you've managed the company, how you've increased revenues or profit over time, or if there has been variability in the performance of your company. It will tell the whole story, either steadily up and then up and down over time, but it could also potentially tell an expert how you have changed things more recently in order to contrive that value after you've filed for divorce. You have to understand that the judges and lawyers and even valuation experts typically work on many cases every year and are always concerned if they start to see a very successful company all of a sudden barely breaking even or even losing money right before the divorce. Even when things really do go downhill for completely legitimate reasons, everyone in this divorce process is skeptical. Most couples lose a bit of focus when going through a divorce because it's emotionally draining, so you'll see business results falter sometimes as well. But if you do anything to really force the company to look worse, make the things that you're trying to do are going to be very apparent to the other side and maybe look not very good in the judge's eyes. So it's best to document most of your decisions in a way that supports that what you're doing is the best you can to continue the business to be successful and profitable during the divorce. Now you continue to run the business like normal, and then you wonder, okay, in a divorce, how do we split the business? Do I have to continue to own this business with my spouse? I've seen times where a judge will allow a divorcing couple to continue to own the business, but usually that is because both people are highly involved in the company and they request to stay in as like joint owners. But even then, it's a real sticky situation for the judge. So typically the courts will want to see one person maintain the business and the other person no longer in the business. Most of the time a couple thinks that they're going to have to buy most of the time couples think they have to buy the person out of the business. And in some respect, this is true. But the reality is we're valuing the business in order to provide a number that we put on your statement of property. And we list it as one of the assets that you own in the marriage. So this means that you could have a business worth $1 million as well as retirement accounts, houses, cars, and other investments. It could be that one person keeps the business worth $1 million and the other person will receive other assets, investments that are equal to that $1 million. There are situations where the business could be the primary asset and has the largest monetary value in the marriage, and there isn't really any other cash or investments or houses to provide the spouse with $1 million of other assets. In this case, there could be a payment for the distribution of those assets over time, and the business owner could be paying the spouse over a certain number of years in order to make the distribution of marital assets equitable or fair in the court's eyes. As a reminder, The rules of divorce are different in each state, which means that the way the assets are divided, if you are in Missouri as opposed to Illinois, Tennessee, or Kansas, could be different. This is one of the reasons that a couple would seek to settle the valuation issues and payments outside of court to have some control over how the property is split. If you have one or both people that are unreasonable with their expectations, then they may still have to go to court and have the judge decide how to split the assets. One of the things I hear most often from business owners is that this business would be worth nothing without me. I'm the business. I have all the customer relationships. If he or she wants the business, they can have it, and I'll just go and start a new one. So almost all business owners think that the business would be worth nothing without them. And maybe the business owner really is the primary salesperson or driver of that business, or maybe they have all the relationships with all of the clients, or maybe they just have some special training or some sort of proprietary process that makes them unique. I think that most business valuation people understand that the business is heavily reliant upon the main owner, especially in small businesses. But that usually does not mean that the business is worth nothing if the owner steps away. And this is definitely true in divorce court. The judge is not going to assume that the business is worth nothing when the same business has provided a significant lifestyle for the couple. This means that if you look back, has your business allowed you to buy a nice house, multiple cars, vacations, private school, and basically a really comfortable living? Well, if that business has provided for the family and increased your assets, then you have to consider that there is value to the business, at least in the eyes of your spouse and the court. So how a valuation analyst treats the significance of the owner becomes a very important issue. And this is why one of the things the expert will review in the course of the valuation is the owner's salary. There are various cases in each state that specifically deal with compensation and a concept called double dip, which is actually a really complex issue in valuation. And it's probably better saved for another conversation. But many times we can incorporate the reliance on that owner in two different ways. One, in the cash flow of the business, or the risk that that cash flow will continue. Take, for example, you have a business owner who makes $250,000 net profit in the business, but pays themselves no salary. They just distribute the cash as necessary for living expenses. Now, if we think the business is worth 4 times profit, then this would be 4 times $250,000 is $1 million, right? Now remember, since this person takes no salary, all of the profit flows to the bottom line. Now in the state of Missouri and many other states, we have to consider the concept called fair market value as the standard of value in a divorce. Fair market value is the value of the business with a willing buyer and a willing seller. This means what is the value of the business to someone who has no knowledge of the industry but would come in and start to operate this company. You know, like basically somebody off the street. For example, if the judge bought this business, how much money would he make and what would he pay for the cash flows? Maybe the new owner would have to hire a manager or CEO to run the business, or a salesperson, or several people. So that might mean that the new operator would have to replace the one business owner with 1 or 2 people, depending upon how much that business owner is involved in the business. So this is where reasonable compensation could be a valuation adjustment in the income statement. The valuation expert would need to add this additional expense, which reduces profit. So let's say that same business owner who is making $250,000 of net profit at the business level should have been paying him $200,000. So now we only have $50,000 left, and the value of the business is only $200,000, or 4 times that $50,000. It's not the million because we had no cost for the owner. And we didn't really have any salary for somebody to replace that owner. So this is kind of the issue of the double dip. And I know what you're thinking. Maybe this business is a pass-through entity or sole proprietorship where the owner doesn't take a salary. The valuation person still typically has to consider a salary to the owner as a pseudo replacement value and adjust the valuation accordingly. This deals with the cash flow, but what about the risk? There could also be increased risk because of owner dependency or key man issues, which reduces value. Typically, these adjustments don't necessarily result in the company having no value, but the value is reduced when taking into consideration the effects of this reliance upon the owner. Again, thinking you as the business owner can just go into court and testify that the business relies upon you and then claim that it is worth nothing without you is a very risky proposition. The judge could look at all the other stuff that you've accumulated and think you are just trying to kind of screw over your spouse. So, are there times when you take out a salary and there is no profit left and therefore no value to the business? Sure, this can happen. But your testimony alone is not going to get you there. Work with a business valuation expert to understand the reality of the situation and how the expert can show the compensation or owner dependency issues in a way that supports your reality, but does it within the constructs of valuation theory and in a way that will stand up to the scrutiny of the judge in the court. Sometimes a business owner will think that they really don't need a valuation because I owned this business before I got married and my name is on everything, so it's just mine, right? Well, there are many times when a business owner has owned a business several years prior to the marriage. So we talk about these issues as the difference between separate property and marital property. Separate property was owned prior to the marriage, and an expert might come in and trace the assets to determine if they are still separate or have they been commingled or turned into marital property. So why do you care? Well, separate property is not divisible in a divorce situation, meaning you don't have to split it with your spouse when you get divorced. This is for certain states that allow these rules. Community property states are different, such as California, Texas, and Arizona, and a few other states. Typically, there are nuances regarding income from a business, especially if it's separate property, that are different than the appreciation in the business. So, for example, in the state of Missouri, income on separate property is marital, but appreciation of separate property could still be separate. So what does this mean? Well, one example is that if you own a share of stock as a separate asset owned before the marriage, then the income or dividends on that stock is still considered marital income that could be divided between the couple. But if the stock price went from $2 a share at the time of marriage to $4 a share at the time of divorce, then that appreciation in the stock, because it's still one share of stock, is still a separate asset, and the value of $4 per share is still considered separate. But if there was marital income that was reinvested to buy more stock, then you could have a portion that is marital and a portion that's separate. See how it gets confusing pretty quickly? So having an expert come in and analyze the investments to understand which portion is marital and which portion is separate, they will also take that analysis and testify to the calculation process in court. So how does this translate to the business? Well, the valuation expert may have to consider what was the value of the business at the date of marriage and what is the value as of the date of divorce. Even if there's a change in value, if the change in value is due to appreciation of that business, then it could still all be separate. But then you have to consider the income from the business, and was it reinvested in the business? Was it paid out in the form of compensation to the owner or distributions of income? And then finally, the valuation expert may have to consider if that compensation or the distributions were reasonable. There could even be a layer of complexity depending upon the structure of the company. So is it a company, is it an LLC, is it a partnership, is it a corporation? Sometimes the issues regarding a business that was created prior to the marriage are not as clear-cut as it would seem. So the valuation expert could have to consider the situation from many different aspects. So now, we have the business covered, but then the entrepreneur is now concerned about the other assets or investment accounts. They might wonder, how do I protect all the other investments I owned before I got married? Well, there are a couple ways that you can protect your assets or investments that you owned prior to when you got married, but most of the ways involve some planning prior to marriage. So there are prenuptial agreements that are one way to clearly establish how things get separated if you get divorced. Many times people will not necessarily want to do these at the beginning or before the marriage. So a postnuptial agreement is done during the marriage. The thing with postnups and prenups is they don't always hold up in court, but both parties try to agree to some of the stipulations of what could happen if you get divorced. Many times I've seen some of the best planning done by very wealthy families who want to protect the wealth for each generation and want to preserve it from getting dissipated or lowered in a divorce. For example, there was one case where the house that the couple lived in was really owned by the wife's parents' estate and held in a trust that would not transfer until the parents died. So the couple was living in this beautiful mansion, and after the couple filed for divorce, the husband thought that the wife would keep the business and the husband would take the house, since they were worth roughly the same amount. The problem was the couple really didn't own the house. Now, there are always other issues when money to buy a house was gifted to another couple, but after the divorce, the checks were clearly gifted to the wife only, and therefore there was a portion of the house that was separate and a portion that was marital. Not as easy to figure out, right? But you just need to keep some clear records of any gifts or inheritances because these are typically separate property. One of the ways is to keep track of what you had prior to the marriage, meaning keep the investment account statements and do not commingle your accounts. So if you have an investment account with $100,000 prior to the marriage, set up arrangements with the financial institution that any income or dividends will not be reinvested in that same account, but actually be put into another account that is a joint marital account. Because remember, the income could be marital, but at a minimum, the accounts would be easier to trace back to the time of marriage. This is just one way to prevent the accounts from being commingled or mixed together and considered transmuted or converted from separate to marital. And realistically, if the valuation expert you're working with doesn't understand these concepts of commingling or transmutation of property surrounding marital and separate accounts in your state, and this is an issue in your situation, you really might want to consider contacting some other people who have dealt with these issues. Another question is, how much am I going to have to pay my spouse in alimony or child support? Well, one of the ways a valuation expert may get involved in a divorce is in the calculations of maintenance or alimony and child support. The expert will typically review the personal tax returns and the business information in order to determine the income available to the couple. They're looking at what each person has made in the form of salary, W-2 wages, consulting agreements, or income from various business interests. Typically, the expert will review 3 to 5 years of information and see if there are any trends or patterns. If one spouse has not worked over the past several years in order to be at home with the family, there could be an additional expert hired called a vocational rehabilitation expert. This expert will determine what that person could make if they were to enter the workforce again, given their background, education, prior work experience, and work history. So this is typically a very different expert and one that only focuses on this narrow job, which is determine a reasonable salary for a non-working spouse or spouse that is not working at their fullest potential. So after this voc rehab specialist determines the non-working spouse's salary, then the valuation expert could determine a reasonable salary for the working spouse. Many times an executive with a W-2 salary and bonus is easier to determine the salary than that of a business owner, which their salary may fluctuate more with business cycles or just be different from year to year. This is where you could have two experts that differ in their opinion of the salary because you have this kind of variability in the historical pay. Many times, if the business is not doing well, the owner might not take as much in salary or distributions. And when the business is doing really well, then they may take a little bit more. So we're at the point that we can determine what would be reasonable going forward. So there are times when a business owner may try to take less money out of the business for salary when they're getting divorced because they think that that will show a better picture to the court. But many times the court is going to look at the history of payments, and a big drop-off in the year prior to divorce could again signal that it's just a one-time situation. So this is another case of where you should just continue doing things as you normally do them. And that doesn't mean to show the appearance of you trying to manipulate the numbers for your benefit. Okay, so now we have another question of why do we have to hire two experts? And do I have to pay for both of them? Well, most of the time, both people will hire an attorney and an expert to testify to the value of the business and potentially develop alimony and child support scenarios for the court. Unfortunately, many times this results in one expert value coming in at the business really high and another valuation expert value the business really low. This is because there are times when the judge will see two experts who have extensive backgrounds and who appear to know what they're doing, or maybe it's just really a complicated business. And now the judge believes that both experts have reasonable values. The problem is those values are millions of dollars apart. And so instead of going with just one expert, the court could come in and average those two values and basically split it down the middle. So this means that if one expert said that the business is worth $1 million and the other expert said that the business is worth nothing, then the court could say that the business is worth $500,000. As much as this doesn't seem reasonable or fair to the business owner, this is a distinct possibility of what could happen at trial. In an ideal world, each attorney is hiring an expert so that they understand what the value of the company is and what some of the risks are in going to court. So are there some risks that the business could be separate and therefore not a divisible asset in court? There are risks that the business could be worth nothing, and then there could be nothing to split in court. Or are there any risks that the attorney cannot identify without using a valuation expert to go through all the historical financials and help them become smarter about the current situation? Now, if the situation is such that you have one primary business owner who makes all the money for the family, and then one of the spouses stay at home, or they're not the primary wage earner, then you could have a situation where both experts are going to be paid out of the marital money. So in some cases, yes, you're going to be if you're the main wage earner, you could be paying for both experts. There are also times when the non-wage earning spouse and their attorney will go into court and ask for the fees of the other expert, and they are requesting that payment come from the business owner or the person who is making the most money in the situation or controlling the finances, and they're asking for that money to be used in the divorce process. In some other situations, each person is going to be responsible for their attorney's fees and their expert fees. But if you consider that those fees are still going to be paid when all of the assets or property and debts are split between the two parties, then those expenses really are still coming out of marital money. So, are there ways that you can hire one expert to determine the value and save some time, effort, money? Of course there is. But you both have to agree to hire that one person. And most of the time, this will happen when both attorneys know the same expert and believe that this expert is reasonable and impartial. Typically, this valuation expert will work for both parties and be able to work through the valuation and present the numbers to both the couple and the attorneys at the same time. There is a process and strategy around using one expert by both people, and not all experts are capable and effective at this role. There could be times where each side offers up its top 2 or 3 experts, and hopefully there's one expert that is on both lists. Therefore, they can be utilized by both parties. So now, another question that we have is, do I have to file for divorce, or are there other options? I'm sure you're thinking at this point that this divorce process does not seem as simple as you originally thought. And typically, if the divorce involves a business valuation or more complicated financial issues, then you're probably correct. There are other options to getting divorced depending upon your situation, your relationship with your spouse, your communication history with your spouse, or even depending upon your financial situation. There are times when the couple has drifted apart over time and are making decision to separate permanently, and mediation or the collaborative divorce process could be beneficial. Most of the time, a business owner may want to have a little bit more control over the process, and they are trying to achieve a reasonable resolution with a mediator or collaborative divorce professional. But you just need somebody who has all of those skills. Sometimes it's helpful to work with somebody who understands the complexities of your divorce and can translate the issues to your spouse. When one person is not involved in the business, there could be a learning curve in just understanding how it is valued. At a minimum, have a meeting or conversation with a valuation expert. Do you think that they could help your spouse to understand the issues, or would they just be more confused? One thing to keep in mind, no matter what process you utilize to come to an agreement on all the financial issues or children issues, you will still typically need a lawyer at the end to file the divorce papers and write up the agreements. So now, I'm considering filing for divorce, but I want to be prepared. What should I do next? Give us a call. No, really. You should reach out to somebody who specializes in valuations for the purpose of divorce. There may be valuation companies near you, but do they understand the divorce court system in your state? That would be a good first question to ask. Then see how many times they've testified. Are they trained as a mediator? Do they understand how to negotiate these settlements with other experts? Well, if you have any additional questions or you want to talk about your specific situation, give us a call at 314-541-8163 or check out our website at valuationstlouis.com.